Welcome to Tamimi Company's video series. My name is Khushboo Shahdadpuri, a partner with Tamimi Company. Today in this series, we're going to be drilling down on energy projects, energy transition, and energy disputes. This is particularly relevant considering the recent climate, considering the energy transition, and the changes that governments are trying to make in the region towards net zero. This is also really relevant with respect to the region's landscape and the direct correlation between political stability and the supply, access, and pricing of natural resources. In today's conversation, I'm very pleased that we're joined with Baiju Vasani, a barrister and arbitrator with 20 Essex. Baiju needs no introduction. He's a global citizen of the world and has worked on some of the most landmark, high-profile, and sensitive cases in the world. He's been ranked among some of the leading chambers and guides in the world. And we're really pleased that he's here with us today in Dubai and in Tamimi's office to have this conversation with us.
Thank you, Khushboo. Thank you for having me.
So, Baiju, let's go straight into this energy transition towards net zero that I was alluding to earlier. And at its core, net zero is simply initiatives being taken either by governments, by private individuals or companies to shift towards more sustainable economies. And the reason why they do this is to obviously reduce the greenhouse gas emissions and limit the increase of global temperatures rising. And I say limit because it's already too late, to be honest, considering what's been happening. It's not just this region, really. It's the entire world is vulnerable to these climate change impacts, whether it's the snow caps that are melting, whether it's the frequency of the heat waves we see in South Asia and South America, or it's the availability of fresh water these days. All of these are serious, dire consequences of climate change. What are governments, what are activists really doing about all of these dire issues at its core? How achievable are these net zero targets? What are the mitigation plans and the backlashes that we see?
Thanks, Khushboo. So you're absolutely right. This is the most pressing issue of our generation and certainly, I think, our children's generation. The key is finance, because whatever governments want to do, whatever NGOs want to do, whatever these companies want to do, you need money to be able to do it. And transition from reliance on fossil fuels to more greener energy is going to cost significant amounts of money. So McKinsey has estimated that it will cost hundreds of trillions of dollars to move us from where we are today to net zero in 2050. So the question is, where does that money come from and how can we encourage it? And of course, the key is that that money is primarily in the developed world, whereas the consequences of climate change is being felt mostly in the developing world. So we have to move that money, that technology, that know-how from one part of the world to the other. Now, in our field, the best way to do that is through legal stability, because obviously people will put money into projects that make money for them, but also where they are de-risked. And that's why one of the key aspects is the question of regulation, legal stability. And one of the most unfortunate developments side by side with this need for movement to net zero is the backlash against ISDS. So the backlash against treaties, for example, the ECT, the Energy Charter Treaty, which was specifically designed to protect energy projects. And what you've seen is in Europe, Western European nations particularly were sued repeatedly over renewable energy projects that went wrong. And now those same nations have withdrawn from that treaty, citing, ironically, that they protect fossil fuel projects. That's true. Yeah. They do protect fossil fuel projects, but they also protect green energy projects. And by pulling themselves out and leaving that treaty exposed, essentially it leaves the green energy projects exposed. So, ironically, these same nations that want net zero, that need net zero, are pulling the plank that would otherwise protect these major projects. So I think one thing that nations need to be aware of is the use of ISDS, which I think is very important to give investors comfort that their money is going to be safe and de-risking them so that actually this climate finance moves from one part of the world to another. The other thing I think that's critical, that's often overlooked, is the need to balance communities, indigenous communities, because I think we've got a green rush, what I would call a green rush, which is that in order to run these new technologies, renewable energy, you also need minerals, right? You need lithium, bauxite, these critical rare earth minerals. And you've seen various governments talk about the need for these kind of materials. But that is an extractive industry that has a risk of danger to communities. So there needs to be an absolute balance. And here again, I think that the regulations, legal stability needs to balance not just the right of the investor, not just the right of the state as qua sovereign, but also these communities that sit somewhere in the middle and often get overlooked.
So you mentioned obviously the sanctity of ICDS, and that I think, cannot be disputed. But before we even come to the ISDS stage, there needs to be a buy-in from the indigenous and local communities, and I think we cannot get away from any dispute as long as the right communities are buying into this whole net zero carbon emission change. And something I think worth exploring is this concept of equitable benefit sharing as a solution, because it basically just distributes the benefits and burdens of shifting away from fossil fuels to the communities that are the most impacted, the most vulnerable. And we've seen examples of this in India where the government have tried to kickstart these initiatives of net zero projects, and the local communities, the agricultural communities have been really deeply impacted and have started riots, strikes. And so there was a huge backlash. And then what happens is then, because of the need to placate these communities, governments go backwards. So before even going to the ISDS stage, this is something governments need to think about more cohesively. It has to be either multilateral treaties, it could be through regional cooperation. Something we've seen in India and Indonesia is governments giving these communities an alternative business base or grants or something just to, even the playing field a little bit. Another action item we have also seen in this whole net zero chase or green rush chase is really shareholder litigation. And this is quite interesting. We've seen this more in the West, in Europe, and not so much in the Middle Eastern region. But we've seen it with, for example, the Climate Earth and the Shell litigation cases where, because of shareholder activism impetus, the cases have been filed by these NGOs and private companies, alleging the directors have a duty to think about the long-term interests of companies. And as part of it, it's obviously the whole action plan to mitigate climate change. In my view, it doesn't immediately lead to very positive results. But having said that, I mean, what results is a very ambiguous term. So the fact that it gains momentum, these issues really gain traction, that in itself is a positive result, really. But I want to move on slightly now to recent events that have been happening in this region, the escalation of the Iran and Israel situation. As we all know, I think it's no surprise that this region is particularly volatile to such political instabilities, to conflicts. But in your view, is there and will there continue to be a direct correlation between the region's political landscape and energy-related disputes? So whether it's through the Qatar blockade that happened a few years ago, the situation in Syria, and now with this Iran and Israel escalation, which we don't know where it's going to come to, obviously. It's still in its nascent stage.
Yeah, I mean, the direct correlation is clear. Any sort of volatility, let alone war, is going to lead to disputes. I think the most obvious way is literal physical impact. So if you've got an investment in a country and the country has war, it could be physical blockade. It could be bombs hitting. It could be workers have to leave the country or management can't fly in and out. Any sort of disruption from a physical level is obviously going to lead to the inability to operate. And the inability to operate is going to lead to legal dispute. You've also then, of course, got what I've called legal warfare, because today warfare is not just physical, but also legal. And for example, sanctions, right? Sanctions are the bane of many a lawyer's life. Others, of course, have created an actual industry advising on it. But for those of us who work in either disputes or in the corporate world, sanctions is a very, very difficult topic to navigate because it's a web, frankly, of different unilateral economic sanctions by different nations saying different things. And so it's very, very difficult for companies and businesses to operate in that type of environment. Then you've got the question of, well, what is the impact if there is war on a contract? Is there a force majeure clause? Is it force majeure? What if there's not? Is there frustration? Is there impossibility? This is particularly true where big prepayments have been made. So, for example, a lot of Russian companies are in a position where they made a lot of prepayments for parts. Those parts were then not forthcoming, and the suppliers suggested, well, we can't because of sanctions or export controls. And then the question is, well, what's the answer to that? And I'm sure that that is happening or has happened with other suppliers now, particularly in the Middle East with what's going on. So there is no doubt of that direct correlation between the two. The final thing I would say is anytime that there is volatility, what you have less of is cooperation and international trade. What you have more of is looking inward, starting to make everything more domestic, right? So that means if I have oil, I'm less likely to share it because now I'm under attack. I think, well, I need to store my oil for myself or my gas for myself. And that leads to nationalization.
Yeah.
It means that there is simply less business internationally and more hoarding by nations, which again is bad for foreign investment and certainly bad for those who have investments that are then nationalized.
I mean, one interesting nuance I thought I might add is during this whole Qatar blockade that was happening, so Qatar didn't actually stop trading its gas with the UAE. So politically, they were not really in any relationship. So transports, roads were blocked. So we had so many arbitration claims coming out of that because of the increase in the supply, increase in the transportation routes, and the resources for a lot of our construction and infrastructure projects. But it's quite interesting. Sometimes with the volatility, we see a different image of what's going on, but on the ground, it could be something else. And you don't actually appreciate it unless you're actually on the ground and you see it.
It's very true. And you have to differentiate between what's in the news, what is actually happening on the ground, and then what contracting parties are claiming.
Yeah.
Because oftentimes it's a very convenient way to get out of a bad contract, right? To say, well, I can't do it, and here's my excuse. But actually, then it turns out not to be the case.
Yeah.
You could have done what you said you can't do, and you're just doing it to get out of a bad contract.
And speaking of claims, so a lot of the energy projects that we see in this region are related to construction and infrastructure claims. There are obviously some that are related to LNG and the supply of these natural resources and gas, but a lot of them are also construction. That's just the way this region works. When it comes to construction and infrastructure claims, I think it's a little bit easier to quantify a delay in a project, an additional scope, a variation, all of these, even loss of productivity for all of its bans. There's still a number we could get to with the right evidence. But I think energy projects are a little bit interesting because you also have these, I call it it's not easily quantifiable, let's say, claims. How do you quantify this? What's the right way of dealing with this? It's tricky because it involves the right experts and the arbitrator.
Yeah, it's a very good question, and it's increasingly something that tribunals are having to deal with. I think the first question you have to ask is it really a compensable loss at all?
Yeah.
And not everything that is damage is for compensatory loss. And so the first thing is admissibility. Is this something for which you can claim? So that's question one. Question two is then, if you reach that hurdle and you say, yes, you can claim for it, then the question goes to how do you quantify it? So I think one can often use proxies. And then the question is, so a proxy would be, how much would it cost to restore? Or how much would a nation pay for something not to happen? You can ask, can I put it into moral damages terms, which is a compensable loss? But frankly, these are all approximations. And then the question goes down to, as you would approach any quantum test, is there enough certainty that the tribunal has that more likely than not, this is the correct number for this loss. And sadly, the true answer is that if you can't estimate the loss with sufficient certainty, then the answer has to be zero.
Yeah.
And that's really an issue. And then you get down to your final point, which I think is very important, which is then you need a different type of expert, which is a little more policy based, a little more comparative in the way they approach things. You have to have tribunals that have a little more creativity, a little more technical knowledge. But I do think it's very important that as a legal community and as a dispute resolution system, we are alive to these types of potentially new losses that are in fact damage.
Yeah.
And are they in fact something that we can calculate? But at the same time, we also have to be careful that we don't have something that's just finger in the air and you're just awarding damages, which end up sometimes looking more like punitive damages, or they're just uncertain and people are picking random numbers out of the air, because then you lose faith in the process altogether.
Yeah, I mean, and it's a difficult one really, because you really can't quantify, for example, damage to health or loss of something that's so sacred to you. I mean, something that I have been advocating to some extent is in the Singapore courts, for example, we have a guideline for how much a particular injury would cost when it comes to accident claims, and those types of insurance claims. And it's not a perfect method, but because there's these guidelines that are binding in the Singapore courts, we have to assess damages through it. The judges are also then bound by the same guidelines. So there's some, in a way, the playing field becomes even. We're all using the same comparative guidelines. And I think that's important in international arbitration, where you have tribunals sitting in multiple jurisdictions, some of which are private, some of which are not. Having these sort of guidelines as some sort of baseline, I think that would be quite helpful then to use as a guide, like how we use the IBA guideline.
Agreed.
But that's not something we have come towards, or it hasn't really been developed. So that's something we should look out.
No, and you're right. And it, as the tribunals that are confidential, the ruling doesn't come out, and those that are in, say, ICSID or UNCITRAL on treaty that do come out, it's very difficult to have any sort of jurisprudence constant between them, unless and until you get sufficient number. And even then, there's such fragmentation. So I think international arbitration is probably not the right place for that kind of standard to be developed. It would be a court system, which would then hopefully spread as something that's customary or a norm.
Yeah. And so this leads me to really think it's really an horses for courses kind of question, right? Who are we really appointing? And this is a bit of a cheeky one, but like, what would you say would be the most important characteristics or skill sets you would look at? Something we've been speaking about as a community for ages. Who are we really appointing? Do they have the right skill set? A time commitment? Previously we would just, in the region 10 years ago when I moved, we would just appoint a silk to be an arbitrator. But now we're really rethinking. The clients are really rethinking. It's not really about age, gender, and all of this are important, obviously, to sort of diversify the pool of candidates. But is the person we are picking just a common law educated person sitting in London? Or does the person, it could be someone in Africa, it could be someone in China, do they have the right skill set to think about these political issues and whichever issues that we are facing in this arbitration?
Yeah, it's a great question. As you said, it's a perennial question that we constantly ask ourselves, and maybe one day we'll stop asking because we'll get it right. But it continues to be the case. Survey after survey shows that people choose arbitrators based on reputation.
Okay.
Right? That's the number one factor, not skill set, not technical fluency, not previous rulings, but just their name. And the reason for that, of course, is, I would say, safety and reputation. So, for example, why we buy brands of particular computer or a car, because you think that brand equals reliability, right? You know what you're buying.
Yeah.
If you buy something new that's different, then you're taking a risk. Maybe it's the best car you've ever bought, or it could just fall apart and you think, well, I wish I had just bought it. But if you buy the top brand and something goes wrong, you say, well, I bought the top brand. Right? So why blame? You can't blame me. So for lawyers who input, for in-house counsel who then go to the board and say, if they lose the case, the first question is, well, who did you appoint? And if you say, well, I appointed the best of the best, then, well, it wasn't my fault. But if you said, listen, I thought about it very carefully. I pieced it all together, and I appointed someone fresh, new, different, and then it goes wrong. Then it could be your fault.
Yeah.
So it's a very, very difficult chicken and egg situation. That said, I am a big proponent of horses for courses. I really do think that there are arbitrators appointed to cases based on reputation alone who are not suited for that particular case. And we really should start thinking about not just legal expertise, so common law equals common law, but much more in terms of regional, because I think there is a regionalization of disputes now. The Middle East itself has a huge amount of disputes that naturally would look to London for its home, or Francophone Africa looks to Paris, or Latin America, right, with the Spanish speakers. So it used to be that this would all come down to a few arbitral centers. I think that's changing rapidly, where regionalization now and knowledge is the key. The other thing, I think we talk about energy disputes, there are now specific arbitrators and experts, even quantum experts, who are energy specialists. And I do think that's very important, because when you're talking about extractive industries, do they know the difference between resources and reserves? Do they know in mining what is a JORC standard? Right? Do they know in renewable energies how to do different analysis of the technical components? In construction, you have its own bar. So I think the energy bar is now its own bar, and really people should be thinking about specialists in that field.
Yeah. I mean, I completely agree with that. I mean, the only, I would say, I suppose, not really an issue, but something we see as in the region is we don't have these energy experts based here. A lot of them are still in the US, maybe in the UK as well. So there's that regional sort of boundaries that we need to also start thinking a little bit about. 10 years ago, when I moved to the region, clients would just hate picking out an arbitrator or an expert that's based here. Everybody wanted to go to the UK. But that's changing. And it is changing in such a rapid pace. And now all of our clients just want people that are based here. Or, not if they're not based here, at least have some sort of signature here, have some proximity here. So I think that's going to be a shift that we still need to see for the energy bar, as you said, for the experts and the arbitrators to make that shift towards the region. And that's going to happen slowly but surely, of course. That's going to change the climate a little bit. But the last question I wanted to touch on between us before we break off was technology-driven disputes. And we have been writing so much about this. We see a lot of jurisprudence, academic articles about how technology disputes are going to prevail in the region. We haven't actually seen this much take off on the ground here. But the one item which has made a lot of noise is carbon capture technology. And it's such an innovative and interesting piece of technology, because it's really a way you safeguard all of mitigate all of the negative emissions from going out in the environment. But yet it could be just a single weld or something goes wrong, and everything could be so destructive. Now, Aramco is just in its testing phase, and just early in March this year, it had a testing facility for carbon capture storage. It's still going on in the testing phase, of course, but what kind of disputes do you see in the technology-driven disputes? What do you think will happen in that phase? How is it going to, how do you foresee it being in an arbitration? How do you foresee that it was going to play out?
So I think we could look at how renewable energy disputes played out in a similar way, because that was new technology 20, 30 years ago. And what was interesting is new technology is expensive, right? Because building structures, having the new technology, the R&D that's gone into the technology. So I think one can anticipate that there are going to be disputes because it goes wrong. We're still in sort of guinea pig phases and testing phases. Plus, it's expensive. So there's going to be big disputes. So I think for sure we can anticipate that there will be disputes, and they'll be big. I think two interesting things that have, again, arisen in the renewable energy space, which I think could be important for new technology, is how does one quantify the valuation technology? If you don't understand it, or if it's new, it's very hard to give it standards, right? It's very difficult to accept that, yes, it's worth this when there's no comparator, for example. And, one way of doing an analysis of any valuation is to compare it to something else that's been sold. But if it's new technology, it's unique, it's one and only, then it's very hard to quantify. Another thing is causation. How do you know that an issue here was caused by something else? Because you don't have the standard. It's not like you can call an expert who says, well, in 3 other places, this happened and this happened. So it's very difficult with new technology to understand causation aspects, that something caused the particular loss. And then how does one quantify that loss? Particularly, again, when new technology, look at televisions, for example, right? I go to the store and there's LED, OLED, ELED, right? All these different technologies. You'll go again in 6 months, and the one that was super expensive is now super cheap, and there's something new in its place. So that kind of movement of technology, something that's brand new and fresh and expensive today is a dinosaur a year from now.
Yeah.
Again, how do you value that? Do you value that from the beginning? Do you value that at the loss point? So that is something I think that we've seen in the renewable space with solar, wind. I think you can see the same thing. You will see the same thing with carbon capture.
Baiju, it was such a pleasure to have you here today with us. Excellent insights as always. Thank you so much. And we look forward to continuing this really interesting conversation again soon.
Thank you very much.